July 18th, 2012 was the last day. Did he die of natural causes? Did he die of a heart attack? Did he die of some sort of infirmity? No. Mr. Daniels was murdered. He had broken ribs, a broken jaw, a broken nose, stabbed numerous times around the face, and he bled to death. And who caused this? Who did this? This person right here, the defendant. You will hear evidence that will prove beyond a reasonable doubt that this defendant committed the offense of first-degree murder and home invasion. You will hear evidence that on July 18th, 2012, in the early morning hours, this defendant had consumed alcohol and had an altercation with James McAllister and James Prather, and that this defendant was angry. And through the course of this altercation, he told James McAllister, "I will break into your house and I will kill you." And approximately 30 to 45 minutes later, Mr. Daniels was murdered. You will hear evidence that Mr. Daniels' house is approximately 300 yards away from Mr. McAllister's residence. You will also hear evidence of the scientific type that will prove this defendant was in that house. You will hear evidence that this defendant's fingerprint was in the blood of Mr. Daniels. You will hear evidence that this defendant's toe print was in the house. You will also hear evidence that Mr. Daniels' blood was on the defendant. In addition, you will hear evidence from text messages where this defendant stated, "I effed up," at approximately 3:50 in the morning on July 18th, 2012. You will also hear evidence of this defendant telling his friends, "I am going to prison."
First and foremost, it's important for me as defense counsel to thank you sincerely for your service. In particular, in a case where the evidence is so gruesome and the outcome and consequences are so tragic. Along with what the judge has told you in terms of the defendant need not present evidence on his own behalf because the state has the burden and the only burden of going forward by bringing you proof beyond all reasonable doubt of guilt. There's other suggestions that are going to be made at the end of the trial. And if I'm correct, the judge is going to instruct you also that you can't guide your verdict based upon sympathy or prejudice. In fact, contrary to what some people think, lawyers are human too, and I'm sympathetic as well. But today, and through the next couple of days, we're going to be making decisions based purely on fact. And with that, keeping the state to its burden. At the end of the case, you're not going to be asked to render a verdict of guilt or innocence. You're going to be asked to render a verdict of guilt or not guilt, proved or not proven. It's my job to keep the state to its highest standard, to make sure that they bring believable, credible, reliable evidence to you in order to penetrate that protective shield we know as the presumption of innocence. Indeed, until the end of the case, that presumption rests with the defendant on into your deliberations. Further, it's my job to caution you that what the state has already said is not evidence. It's merely what the state hopes to prove. Neither is what I'm saying evidence. It's merely a cautionary procedure in the outline of our criminal justice system to make sure that those charged with crimes are given the proper protections, and those prosecuting those, the government, brings forth all evidence that they are required to. Now, there's two types of evidence. There's direct evidence, that'd be observational. You see with your eyes, you feel, you hear. You're actually part of an observation of something taking place, an action. Then there's circumstantial evidence. I think the evidence will show that this case is overwhelmingly circumstantial. And in order to build a case that's circumstantial, corroborating evidence must be presented of a believable, credible, and reliable kind. You'll be asked to make that decision at the end of the trial. And once again, with sincere thanks, you know that your time is appreciated. and is probably a moment of service in your life that you'll never forget.